Tsikata. I'll have two matters for you. One is a bit straightforward, the other not. On this question of principle for upholding or annulling election results, earlier you quoted from you read the election of Vice President appear as Attorney General. I think you quoted the first part, which supports what is, but the second part seems to be virtually, evenly balancing the force of the first part. It says that it says one thing in one breath is fine, but when you read the subsequent one, it gives the impression that non-compliance with statutory provisions can have some consequence. So I don't know exactly.
Well, my lords, respectfully, the case that we quoted from, as your lordship indicated, is a case in which Mr. Edward Akufo-Addo's election as president was being challenged by Mr. Joe Appiah. And one of the bases of the challenge was that, the main basis in fact, was that certain regulations in respect of the conduct of the election had not been complied with, and that there had been an attempt to use regulations that were not applicable to the presidential elections in that context. And Mr. Justice Charles Crabb, who was then the interim electoral commissioner, was said to have played a certain role in terms of advising the authorities in that respect. Now, my lords, the point that we're making is that in that context, the Court of Appeal, presided over by the acting Chief Justice, first of all, determined that on the evidence that was brought before the court, the electoral processes for the various houses of chiefs and so on, those electoral processes had actually taken place. There had been votes of the houses of chiefs to determine their representatives, to determine who they were voting for, and so on. And my lords, the point that we were seeking to do, incidentally, my lords, there was also a very significant observation of their lordships in respect of the changing account of the petitioner in that case, the changing account as regards what exactly they were bringing to court. The court noted that that itself was part of the weakness of their case. But my lords, in the conclusion that we are adverting to, the court recognized that not only were their votes actually counted leading to the declaration of results, not only were, and once those votes were counted and led to a declaration, the court was saying that even if the advice of Justice Charles Crabb was sought, which was not necessary, it was not, it was not a requirement that Justice Charles Crabb, as interim electoral commissioner, should have anything to do, but the seeking of that advice in respect of the conduct did not in any way affect the conduct by the proper authority of the election. That's my understanding, but I'm not quite sure I understand when your lordship said one part supports us and another part is balanced. I'm not sure which passage your lordship is referring to.
Look at it again. But I think the substance of the approach of the Court of Appeal there was that because there were no regulations put in place to govern that election, the Electoral Commissioner had a discretion to borrow from whichever regime of law that he felt. And even though Charles Crabb had his own area for legislature, and he made regulations, they could only apply if it didn't go into the area reserved to the Electoral Commissioner himself, the returning officer.
Yeah.
But the court said, but once there were no real prescribed rules, he could also borrow even from Charles Crabb's rules. It didn't matter that they were not made by him. That's how the whole thing is. Anyway, the other point is the submission about retroactive application, retroactive invalidation of results. I couldn't catch that very well.
Very well. My lords, you would recall that it was my submission that there is nowhere in the Constitution where Article 49 can be said to lead to an annulment of a vote. There's nowhere. And the submission about retroactive penalization was part of our justification for not interpreting Article 49 in a manner that would have that effect. Because, my lords, what we are saying is that Article 49 is clear on its terms. A public duty is imposed on both the presiding officer and the candidate's agents, if present, to sign. There is a clear public duty in Article 49. We can't, disregard that. Now, Article 49 does not say that if that public duty is not performed, you annul votes. It doesn't say that. So our submission is this: in the consideration of what your lordships are going to do in respect of the failure to perform that public duty, your lordships' interpretation should be guided by a number of constitutional principles. And included amongst those constitutional principles is the principle that, as far as possible, the courts do not, or indeed, not just the courts, but anybody, legislature, and so on, as far as possible, there is a frowning on penalizing people retroactively. That is one of the principles under which the Constitution operates. So what we are saying here is that even the presiding officer, my lords, the presiding officer who has failed to perform the public duty, you cannot just on that basis seek to punish him without a specific written law which creates a criminal offense which he is then subjected to. You cannot do that. How much more the voter? The voter has done nothing wrong, and then the presiding officer is a person effectively trying to invalidate the voter's vote retroactively. And we are saying, my lords, that no justifiable interpretation of Article 49 can lead to such a conclusion, because Article 49 must be read within the context of all the constitutional principles that are available. And those constitutional principles include this frowning on retroactive penalization. They also include the fact that in Article 42 there's a very clear right to vote. And, my lords, there are also clear principles as to what you do if you do not, if somebody does not comply with the Constitution. So Article 2, for instance, talks about what happens to a person if somebody is alleging that somebody has, failed to perform his public duty under the Constitution. So in that context, for instance, somebody like the presiding officer could, under Article 2(4), he could come and his failure to obey any order of the court, if an application is brought saying that you, the presiding officer, have failed to perform your public duty, he then comes and the court may give an order that you sign. If he fails to sign, at that point, then 2(4) will kick in, where he can be said to be guilty of a high crime and so on. So, my Lord, the point that we are making is that the interpretation of 49 cannot, by any stretch of the imagination, include an effect of retroactively penalizing a voter. Because even the presiding officer is not retroactively penalized for his failure to perform the public duty. And in the case of the voter who actually has a constitutional right, the matter we respectfully submit is a for sure right, that you cannot, for something, he has not done anything wrong, his vote was counted as valid, and you cannot, after the event, then seek to reverse that. That is the submission that we're making. Now, my lords, it's quite clear that we did not suggest by any means that there was literally a criminal penalty on the voter. That was never part of the submission. What we said was that effectively, if you came to that conclusion, effectively, you would be penalizing him. That was our submission.
Well, we've heard you. Mr. Tsikata, this Addison's position is that there's no mix-up in their exhibits and anything. Yours is that there is a definite, there's some confusion and so forth. You've heard him. What is your, how do you sustain your stand?
Well, my lord, Appendix 1 of that we attach to our written address is very clear. I don't think he has addressed that at all. Appendix 1 is very clear. You have 2,120 polling stations, and as we indicated, 1,060 of them have an exhibit number with one set of polling stations. 1,060 of them have the same exhibit number but different polling stations. Now, he has not responded to that. And my lords, it came up in cross-examination. I remember when Mr. Niamano Dudu was in the witness box, we identified some of these, and I believe at a certain point after we identified a few, one of your lordships pointed out that it's clear in the KPMG report. So, my lord, the confusion has not been addressed in any way. He is just saying, and my lords, this reference to respondents' preferred sets, I mean, it's meaningless as far as we are concerned, because what he claims is our preferred set has nothing to do with us. That is their own invention. We have said all the time that there is complete confusion in the exhibits that have been filed. The reference, for instance, to recategorization with leave. Leave has never been sought before this court to recategorize anything. No leave has been sought, to my knowledge. Certainly not enough participation here. But the more important and significant thing is what we've indicated in appendices 1 and 1A, where those 2,120 and then 1,725 respectively. In the case of the 2,120, your lordships respectfully are not going to be the ones to decide as between the same exhibit number but two different polling stations. They are seeking to annul votes by reference to these exhibit numbers. So which polling station are we talking about? If we take, an exhibit P, MBP, which has two different polling stations, two different exhibits. Which polling station are we talking about? And here we are talking about the serious matter of trying to annul votes of people. So your lordships, and indeed we as respondents, we should be in no doubt as to, and indeed the voters also out there should be in no doubt as to whose votes are being sought to be annulled. So if you bring an exhibit, that is exhibit P, that has polling station A, and then you bring another exhibit P, MBP, which has polling station B, we cannot choose for you which of those two polling stations you're seeking to have annulled. And that is why we also made the submission in our written address that from the time this matter began to be pointed out in court, the petitioners had every opportunity to clarify the situation. They had every opportunity to come to this court and say, we have made a mistake. My lords, they said this morning they've made certain mistakes in the index. The mistakes, continue. They cannot, they need to come to court and say, this is a mistake. One set, the 1,060 that we labeled in relation to this polling station were wrongly labeled. They actually applied to something else. If they had come and said that, then we'll be in a position to say, okay, this is the thing. And then, my lords, another important thing that we've indicated is that where you have exhibits that are outside the range of the affidavit, no explanation has been provided for that.
Well, I'm not give you another list of this, but because what you are saying is all here. I thought you had some other, but all those are here. All right. Okay, thank you. Sorry.